Since it's a public hearing, should the motions be read in this public hearing and displayed for the public to view?
It will be entered into the public record.
That wasn't my question. Should it be read?
There's no need for that. The board has read it, and the board's the one making the decision here. So if anyone in the public wants to see the document upon which the board made their decision, they're free to, because it will be in the record.
Okay, thank you.
Hold on just a second. Is that the IT? No? Okay. Sorry.
Is this on?
You can continue.
Can you hear me?
Yes.
Good morning, board.
Ms. Easter, do you have any questions?
If she submits, she submitted it to the office or something? This is the first I'm seeing.
We can't hear you all.
Yeah.
We need to take a 5-minute, I'll adjourn for 5 minutes. We can get the IT person. We're adjourned until we can get the technological aspects of this
Can IT
figured
come
out.
in here?
Yeah. Here, we can all. Yeah, we're looking for a happy medium of being able to hear me here versus hearing all the rustling of papers.
Test, test.
And we'll probably need some thumbs up or thumbs down from the back as far as whether you can hear or not.
Test, test. It's good?
Better?
Yeah, it's good.
Can you go back a little bit?
I mumble. How about we try someone else?
Okay.
Can you hear in the back?
HR handles it on their end. I would imagine it's all online through that same system, but I don't know how they handle it.
And once you received the complainant's wife's application, what were the next steps?
So I actually didn't even know that she had applied because the District 5 seat became available on 7/3 after Chair resigned. And I did not know that she had even applied until that motion came up and there was a copy of her application. She applied on 7/22, but I pulled 32 applicants on 7/3 and started the process of replacing the District 5 seat on 7/3 let's see, on 7/3 at 11:54 a.m., I sent a list of 32 applicant addresses over to the Assistant Director, Ms. Phillips of Elections. That's how we verify that those addresses are within the District 5. So once she got back to me, she emailed me back that same day at 3:59 verifying what addresses were in the District 5. On 8/7, I contacted HR and told them that these these 4 applicants were ready to move forward to get drug screening and background checks. On 8/21, at 1:28 p.m., HR sent me an email saying all the 4 applicants had been cleared. So I contacted the DA's office because they're the ones that scheduled the interviews with the grand jury. They scheduled interviews for 9/18 at 11 a.m. So the application process was already finished by 8/7. All the applicants that I had pulled from NeoGov. So I didn't even see Ms. Tripp's application. She wasn't part of the pool.
Thank you. At any point in the application process, is the board informed of the names of the applicants?
Absolutely not.
Thank you. Thank you, Ms. Bannister. Are there any additional questions? Thank you. Is the board ready to vote? Do you want to make the motion?
Well, we can go down the line, yea or nay. Is there anyone who, are there any members of the board?
Stop. Hold on one second.
Yes.
I'm sorry, IT has to come up there and adjust your microphones.
Okay. You need to- Okay, thank you.
Are there any members of the board in favor of granting the respondent Morris's motion to dismiss? Motion denied. Now, we can continue the hearing that began on October 29th, 2025. Before we begin, I'd like to remind the parties and the board that upon agreement between the parties and the board, the time limits typically imposed in these hearings were waived, which resulted in this hearing not being concluded in one day. One of my duties is to facilitate an efficient resolution of this matter, and to that extent, I did not fulfill my duty on October 29th. I respectfully request that the parties and the board focus on the claims at issue in this case and the facts necessary to resolve those claims. If there's a line of questioning that appears to be going too far off path, I will interrupt and request that the parties or the board focus on the relevant facts at issue. In other words, please be a bit more concise in your presentations of evidence and questioning than you were on October 29th. If not, you're probably going to hear from me about it. That said, would complainant please call your next witness?
I'll call Holly Henry.
Mr. Casper? I'm sorry to interrupt.
Yes, hold on just a second, please.
I'm sorry. I was just pulled aside. The county manager has requested that all the employees leave the room and head back to their department because their counsel has told them that they do not need to be here. I asked the county manager if she'd like to come in to talk to the board, and they said no. Oh, there she comes. I don't know if she can.
Well, you're free to take that advice or not. So if you would like to stay voluntarily, you're free to do so. If you would like to disregard the contents of the subpoena, do so at your own will.
So am I correct, they are being told to disregard any subpoenas?
That appears to be correct.
Thank you.
Chair.
Yes.
Did you want? I'm sorry, I do redact. It was not the county manager's request, it was Chair Harrell's request, the county commissioner. Their county attorney advised them that the Henry County Board of Ethics does not have the authority to subpoena employees.
Has the county attorney chosen to make an appearance? Has the county attorney read the?
Is the county attorney here? Is the county attorney here? Is she here in the building? Okay, she sent a letter? Oh.
That's the letter.
That's the, okay, yeah. So she says the county attorney sent the letter that the board should have a copy of that. Did you put a copy of that? You put a copy of that letter?
When was the letter sent?
It was forwarded to all of you. Ms. Bullard did not put a copy in there. We didn't think we would need that, but it was the email, the letter from the county attorney that was forwarded to the entire board.
So could someone point me to the line in the bill, Senate Bill 22, that states,
That the board has power of subpoena.
yeah, well, that the board has power of subpoena, but also that we're not under the supervision of the Henry County chairperson or the,
Yes, ma'am. If you just give Ms. Bullard just a few minutes, she'll be able to find that for you.
thank you.
I found it. Section 5.7 subpoenas. Are we still on the record? For use in proceedings under this section, the Board of Ethics shall have the power to issue subpoenas to compel any person to appear, give sworn testimony, or produce documentary or other evidence. Any person who fails to respond to such subpoenas may be subjected to the penalties set forth in subsection 6 of this section.
In addition, page 21. Oh, no, that's the same. That,
Now, is
Mr.
that,
Cascos has read it.
well, then the question remains to the board, do we continue this hearing without any witnesses, get it done today? Or do we continue this for another day until we can hear from this county attorney regarding the advice to disregard the subpoenas?
So investigations and hearings. The Board of Ethics shall conduct investigations into alleged violations of code of ethics. Investigations and hearings. The Board of Ethics shall conduct investigations into alleged violations of the code of ethics, hold hearings, and issue decisions as prescribed in the subsection. The proceedings and records of the Board of Ethics shall be open unless otherwise permitted by state law. Upon request of the Board of Ethics and Henry County Solicitor or any attorney representing the office of Henry County Solicitor, or in the event of a conflict, any attorney who shall be selected by a majority vote of the Board of Ethics shall advise the Board of Ethics. So we will get legal representation to advise us moving forward, but as it states in the bill, we, as the Board of Ethics, do have the right to subpoena witnesses.
Yes, Senate Bill 22 specifically states, for use in proceedings under this section, the Board of Ethics shall have the power to issue subpoenas to compel any person to appear, give sworn testimony, or produce documentary or other evidence. Therefore, the senators of Georgia have bestowed upon this board the ability to issue subpoenas, which were just disregarded upon advice of counsel. So the board is certainly at liberty to continue. I don't mean continue to a later date. I mean continue here today to hear this issue and decide this issue here today and decide how to address the failure to appear pursuant to those subpoenas at a later date, should it so choose. So the question is, do we have this hearing today?
It also says, all testimony shall be under oath, which shall be administered by a member of the Board of Ethics. Any person who appears before the Board of Ethics shall have all the due process rights, privileges, and responsibilities of a witness appearing before the courts of this state. So are they saying when subpoenaed for the court of the state, they don't show? There's a process to that, right?
They're subject to penalty for not showing.
That's what I thought.
The question is essentially, does the board want to pursue those? My question really, though, goes to respondents. Did the respondents issue any subpoenas, or are these all complainants?
They did, the respondents issued 6 subpoenas.
And have all those people left?
They did, upon the advice of Henry County Council and Chairperson.
So that's a question for the respondents, because they issued 6 of those.
Respondent, that is a good question for you, because it's your due process that's at issue here. And those individuals that left just disregarded lawfully issued subpoenas. So it's up to you whether you would like to continue here today or postpone this hearing to a later date so the issue of the issuance of the subpoenas can be addressed with, was it the county or the city county attorney?
The county attorney.
So, just so we have it on the record, subsection M, violations of appeals. Any intentional violation of this section, furnishing of false or misleading information to the Board of Ethics or the ethics officer, failure to follow an opinion rendered by the Board of Ethics, or failure to comply with the subpoena issued by the Board of Ethics pursuant to this section shall be subject the violator to any or one or more of the following: administrative sanction of not more than $1,000 assessed by the Board of Ethics, public reprimand by the Board of Ethics, and prosecution by the Henry County Solicitor and the Magistrate Court of Henry County, and upon conviction, a fine of $1,000 per violation, up to 6 months imprisonment, whether the official or employee is elected or appointed, paid or unpaid. I just want to put that on the record.
And I'll just note, for the board, two of the respondents are not here. They've also, left, just so the board and Mr. Morris can take that into consideration when determining if to continue or not.
Mr. Morris, your call right now, whether you want to proceed today or...
Well, obviously, we can't proceed if there are no witnesses, so let's postpone it, I guess.
Board, I don't know that we have any choice in this matter in regards to Mr. Morris's rights to due process. So I
For
appreciate
the
it.
record, we're just going to go to the board and those in favor of postponing. Aye. Raise your hands. Those in favor of postponing this hearing to a further date? Postponing? Yes. Yeah, we're all in agreement. Anybody in disagreement of postponing? Because he can't present his case without his witnesses. It's not here again.
This hearing will be continued. We're adjourned.
IT, where's IT?
They're always in another room.
IT, I need you to cut the mics and the cameras, please.